Good morning, everyone, and good morning to our esteemed speaker. I am Nolita Jali, the Secretary General of NADEL. I will be directing today's program. The name of our session is Interstate Succession and What Happens to Your Estate. The LSSA, the Women's Legal Resources Center, which is based in Cape Town. LSSA is all the attorneys in South Africa. Legal Aid South Africa, which is all the legal aid offices in South Africa. NADEL, which is the National Association of Democratic Lawyers, decided to raise awareness on the importance of wills. We've had our first session where some issues were discussed, and this is our second session. And today we will be dealing with interstate succession. Interstate succession is what happens to you what happens to your estate when you have passed on and you haven't left a will. Our capable speaker, whom I will introduce, will take us through that process. And we hope it makes us aware and prepares us. And as we're running the process, we have attorneys who have put themselves up to assist with drafting of wills in case after this session you decide you want to have a will, you do not want to be interstate. We have attorneys who have placed themselves on the LSSA website, and you can go there and make an appointment with an attorney who will assist you with drafting a will. On that note, ladies and gentlemen, I would like to welcome you all to this session. Let's now deal with the ground rules. Advocate Morake will first talk to us and explain the whole process to us as to what happens when we pass away interstate. And then there will be a question and answer session, which will be fielded by him and Tembeka from Legal Aid South Africa, who is based in East London. And Siham will also assist with fielding the questions. Let me now at this stage introduce our speaker. Advocate Refilwe Morake holds an LLB degree from the University of Mamelodi, Vista University Mamelodi campus. He joined the Department of Justice and Constitutional Development in 2003, where he started as a temp. And in June 2005, he was appointed as an estate controller in the Master of the High Court, Pretoria. On the 24th of October 2005, he was admitted as an advocate of the High Court of South Africa. On the 15th of January 2008, he was appointed as an assistant master at the Master of the High Court, Pretoria. Advocate Morake is passionate about his work, which affects the vulnerable members of our society. Thank you very much. Over to you, Advocate.
Thank you very much. I'm very sorry for the delays and all the interruptions. As I was saying, the interstate succession is governed by Act number 81 of 1987. The law of interstate succession determines who the beneficiaries are since the deceased failed to make a will. Under the interstate succession, one inherits per stripes or by representation. In the past, many blacks didn't leave wills in view of the fact that culture determines who should inherit. Black women couldn't own property, and in most black cultures, it was the oldest male child of the deceased who could inherit, failure which his father or elder brother. The decision of the Constitutional Court in the case of Bear and others versus Magistrate Kayelisha drastically changed the customary law of succession. The facts of the case is that Mr. Bear lived with Miss Bear and their two daughters. There were some doubts as to whether Miss Bear and Mr. Bear were married. Their second daughter lived with the deceased father. in the Eastern Cape. The deceased died without leaving a will in his estate, and his estate was supposed to be distributed in terms of customary law. That means the father of Mr. Bear, the deceased, would have inherited the estate to the exclusion of Ms. Bear and the 2 daughters. The estate consisted of a shack. The father wanted to sell it to pay the funeral costs. Ms. Bear applied to court to have her 2 daughters declared the only beneficiaries of her husband's estate. The Constitutional Court held that customary law of succession was constrained by Section 23 of Black Administration Act. The Section 23 was declared unconstitutional since it discriminates on the basis of gender and birth. In terms of the court decision, all estates of persons who passed on without leaving wills, irrespective of race, gender, or culture, must now be administered in terms of the interstate succession. I have 3 recent constitutional cases which had an impact on our customary marriages. The first one is the Gumede case, Gumede versus the President of the Republic of South Africa, where it was held that Section 7, subsection 1 of the recognition of customary marriages was inconsistent with the Constitution and invalid to the extent that its provisions relate to monogamous customary marriages. From this decision, monogamous customary marriages entered into before the commencement of the Act of Recognition of Customary Marriages Act were deemed to be marriages in community of property. The Gumede decision did not decide on polygamous marriages entered into before commencement of the Act, and such marriages were deemed to be governed by customary law and were regarded as being out of community of property until the decision of the Ramohovi case. In Ramohovi case, the court held that provisions of Section 7, subsection 1 of Recognition of Customary Marriages Act with regard to polygamous customary marriages entered into before commencement of the Act is discriminatory on the basis of race, ethnic, or social origin, insofar as women in such polygamous customary marriages were excluded from the protection afforded to women in monogamous marriages. The Ramohovi case further differentiates between women in old polygamous marriage and women in new polygamous marriages by providing the protection to the latter. Such discrimination was based on one or more grounds listed in Section 9, subsection 3 of our Constitution, and such discrimination was unfair unless justified, and no justification for discrimination was raised in this case. I have the last case of Mayelani versus Ngwenyama. In this case, it was held that husband in Sichonga customary marriage who wish to enter into further customary marriage with another woman after this decision will require the consent of the first customary wife to the second customary marriage. It was also held that the requirements set out in Section 7, subsection 6 of Recognition of Customary Marriages Act for further customary marriages was an additional requirement for the validity of further customary marriage, and failure to comply with these requirements will render the marriage void. The judgment given in respect of Sichonga customary marriage was referred to the state law advisor for legal opinion, and the opinion dated 7 November 2013 was that the judgment applies to all polygamous customary marriages, not only to the Sichonga customary marriages. Who is now the question comes, who is a spouse for purpose of interstate succession? A spouse is anyone who enters into marriage according to marriage, who enters into marriage according to Marriage Act 25 of 1961 is regarded as a spouse. That is a civil marriage. Anyone who enters into customary marriage is recognized as a spouse in terms of Section 2 of Recognition of Customary Marriages Act. Then Section 3, subsection 1 of Reform of Customary Law of Succession and Regulations of Regulated Matters Act 11 of 2009, which came into operation on 20 September 2010, incorporates certain portions of women to qualify as spouses for Interstate Succession Act. Those women are seed-bearing women. A seed-bearing woman is a woman, not surviving spouse, who enters into an agreement according to the customary law for purpose of providing children for his spouse. The second one is a woman who are married according to Muslim and Hindu religions. The third one is partners in permanent same-sex life partnership should be regarded as spouses for interstate succession purpose. The position of a child of the deceased born out of wedlock. A child born out of wedlock inherits from both blood relations or parents, same as the child born in wedlock. The position of an adopted child of the deceased. An adopted child will be deemed to be a child, will be deemed to be a descendant of his or her adoptive parent or parents. What will happen, now the big question is what will happen to your estate when you didn't leave a will? Your estate will be distributed in terms of Interstate Succession Act, meaning certain categories of people can qualify to inherit since you failed to make a will. Distribution of deceased estate under interstate succession. If the deceased is survived by a spouse or spouses, but no descendants, such spouse or spouses shall inherit the estates. Number two, the deceased is survived by descendants, but not by spouse. Such descendants shall inherit the interstate estate. The descendants, I'm referring to the children. The deceased is survived by the spouse as well as descendants. The spouse will inherit half in terms of marriage in community of property. Then she will again inherit the child share, which is 250,000, depending 250,000 or whatever is the greatest. Then there's descendants, such descendants, if there are any, they will inherit the residue if there is any. Remember, in the past, the 250,000 one was amended 19 September 2003. From previously, it was 125,000, the child share. That if the deceased is not survived by a spouse or descendant, but is survived by both parents, his parents will inherit the estate equally. If the deceased is survived by one of his parents, the surviving parent will inherit half of the estate, and the other half will be inherited by the descendants of the deceased parent. The brothers and sisters, if there are any, they are the one who will be inheriting the portion which was supposed to be inherited by the deceased parent. The number 5, the deceased does not leave a spouse, descendants, parents, but only one of the predeceased parent left the descendants. Then the descendants of the predeceased parent who left descendants will inherit the entire estate. Number 6, the deceased did not leave a spouse or descendants, or parents or descendants of his parents, then the nearest blood relations inherit the entire estate. In this instance, the cousins, the uncles, they come into the picture now. If the deceased is not survived by any relative, the whole estate will devolve to the state and the inheritance will be paid into the guardian's fund. After 30 years, if the money is not claimable at the guardian's fund, it will be referred to SARS. Then it will start paying the grants. That's all I have under the interstate succession. Thank you very much. Hello?
Thank you for that, Advocate Morake.
Thank you, ma'am.
Sorry. Thank you, Advocate. I'm going to sorry, it's just that Nolita Jali is not on at the moment, but what we'll do now is to be able to open up the questions, and what we'll do is that we'll direct it to you as well as to Legal Aid South Africa. I'm going to, I don't know if Ru, if you'll be able to, if there's any questions and queries that have come through.
I will check the questions for you in a second. So there's a question from Barbara Lawrence Tredom. Says, thank you for this information. What is the process from death? What are the timelines? Tembela, are you able to take that question?
Okay. When someone passed away and you are aware of that, immediately you will have to report the estate. When you report the estate, you approach the Master of the High Court, which is the nearest office to the deceased. You, at Master's office, you will complete all the necessary documentation, and they will provide you with the letters of authority if an estate is less than an amount of 125,000, which means you received an appointment letter immediately. Wherein an estate is more than 250,000, you will have to appoint an attorney, someone who's going to assist you in winding up the estate. The reason that you have to report an estate immediately, when someone passes away, remember all the assets. For instance, if there are monies at the bank will freeze the money. So it's important for you to approach the master's offices immediately that you become aware.
Thank you very much for that, Tembela. Just, I don't know if there's any other more questions, but I think it's important maybe if you explain who is the master's representative and what happens if your estate is less than 250,000 and you don't have a will.
Okay. In a case where in your estate is less than 125,000 rands, I'll make an example. Let's say if in an estate, the deceased had an amount of the total assets is 400,000 rands, and there are no children, only left the spouse. In that instance, the spouse will inherit the half of the estate. In this case, with the amount of 400,000 rand, their half will be 200,000. The spouse will inherit that 200,000 in terms of Section 11A of the Interstate Succession Act, and the spouse will inherit again, if they are married in commit of property, the child's share. In a case wherein there are children, let's say there's a spouse, there are also children. In that, let's make an example with the amount. There's let's say there's 1 million in estate. With that 1 million again, if the parties are married in community of property, it would mean the wife will be entitled to half of the estate by virtue of the marriage, which is in commuter of property, if they're married in commuter property, meaning the wife will be entitled to 500,000 rand. The wife will again be entitled to the child share. Child share is now 250,000. So it means the wife will take 750,000 rand. Now the question is, what happens to the residue? The residue is an amount of 250,000. It means that the children that are entitled, which are the heirs in this estate, will have the 250,000, which will be divided amongst them equally. Whether those children are born in marriage, and also if those children are born out of wedlock, same thing that Advocate Moraka has already said, that the children that are born out of wedlock doesn't mean those children does not have a right to inherit in their father's or mother's estate.
Thank you, Tembela. There is another question from Patrick Molepo. Asks, can you briefly explain the South African common and customary law of intestate succession?
Okay. When it comes to customary law, I'm not sure whether he was listening at first. Advocate Morake already spoke about our constitutional case of Bear, the Bear decision. If parties are married in terms of customary law, let's say, I'll just make an example. There are two spouses. Both spouses will be entitled to the estate equally. If there's an amount of 500,000, both spouses will share 250, 250. It doesn't say you are the first wife and this one is the second wife or the youngest wife. When we call it as blacks, there's a first, there's an elder, there's a junior. It doesn't work like that. So both will inherit equally. Those that are married in customary law.
Thank you, Tembela. The next question is from Jocelyn Moodley. It reads, if a deceased was divorced with no will and liabilities exceed the assets, how will the L&D account be drawn? The divorced spouse is alive and there are 3 children alive. There's one house valued at 580,000, but there's a bond of 300,000.
Sorry, you're saying if the deceased, come again?
The deceased was divorced. No will and liabilities that exceed the assets. How will the L&D account be drawn? The divorced spouse is alive and there are 3 children who are still alive and one house valued at 580,000 with a bond of 300,000.
Okay, there is no will. All right. First of all, if the parties have divorced, okay, we'll make an example. If when the parties divorced, at the end, there are consequences. If they were married in, there must be a division of the joint estate. Now, if we say those parties have already divided their estate, and now which is the ex-spouse, when we're making a total, taking all his assets as well as liabilities, and then the total assets is 580. It means because he never left a will, he died intestate, the children of the deceased will inherit his assets. But now, at master's office, what would happen? They would take all the total assets, which is the executor will collect all the assets of the deceased, pay the liabilities. As she mentioned that there is a bond, which means the bond is now the liability. At all instances, the executor or executrix of the estate must collect all the assets of the deceased. After collecting the assets of the deceased, you pay all the liabilities. When you pay the liabilities, there will be a residue. If there is a residue, that is the amount that will be divided amongst the heirs. In this case, because the spouse has divorced, the children, there are children in this estate. The children are entitled to their father's or mother's estate.
Thank you, Tembela.
Can I add something on that?
Sure. Sure.
Hello?
Okay, sure. Yes, you may.
Yeah, I had the question saying, they are divorced and their liabilities exceed the assets. And they wanted to know how the L&D will be drafted.
Oh, I didn't hear that part. If
The L&D, the estate will be administered in terms of Section 34 as an insolvent estate. Remember, immediately when we issue with letter of executorship, you have to advertise the estate in terms of Section 29. You are inviting all the creditors. After you have received all the claims, then you have to prepare the L&D account. Should the estate be insolvent, then you have to prepare it, the L&D account in terms of Section 34. You submit the statement of assets and liabilities. That is where we will see that this estate is insolvent. Then mostly if there is a bond, the bondholder is the one which will give direction as to whether the property must be sold at public auction or privately. Then it automatically will leave the estate with a shortfall. The preferred creditors will be paid first. The bondholder will be the preferred creditor. If, let's say, there were small other creditors, but with a little amount, they won't be preferred. They are not ranked within the preferred creditors. The preferred creditor, which is the bondholder, will get whatever is left. That is the residue will go to that bondholder. Then there won't be any distribution. The distribution amount available for distribution will be 0-0. Thank you.
Thank you. Thank you. The next question is from Lynette Weingard. Good day. What happens when the estate goes to the Guardian's Fund and a year later it is discovered that there is a descendant alive? Can that descendant then claim inheritance from the Guardian's Fund?
Okay. First of all, if the money's already been paid at Guidance Fund, remember you came later to say that you are also the descendant. The first step that you need to do, you have to prove, because we can't just say there is the other descendant or whatsoever. If you prove that you're really the child of the deceased, you are entitled to the share, whatever amount that was paid to the Guidance Fund. It means Master's Office will also be involved, because already in a system, as well as the documentation that was assigned and prepared at Master's Office, your name won't appear. So we have to go back and then we'll amend the documentation, and whoever it is that is proven that indeed it is the child of the deceased will be entitled to his or her share.
Thank you, Dimbela. The next question is from Barbara. If there is a will and the executor is the bank and their staff are continuously resigning and the file is not updated and we keep starting over to now almost 3 years, what is the recourse for the wife?
Okay. If there is a will and the bank doesn't want to accept an appointment, is that the question? They renounce.
So yes, their staff resigns and there's just this continuous flow of starting over with the process.
Okay. In that case, I remember, and every time you're not happy with the executor, Section 54, it's about the removal of the executor. If you're not happy about the executor that is not doing his or her duties, you have a right to approach Master's Office, which is Master of the High Court, and advise them that you're not happy, and you state all the reasons for you not being happy. Because in this instance, if you're saying it's 3 years and nothing has been done, which is it's obviously a delay, which is a prejudice to whoever, and also, especially if the minor children were involved, because now they need money, school fees or whatsoever, go to the Master of the High Court and advise them that you're not happy, and you state all your reasons. Section 54, it's about the removal of the executor. 3 years is too much for nothing to be done.
Thank you, Tembela. The next question is, in terms of adopted children who are eligible to inherit the estate, does this only refer to legally adopted children, or do culturally adopted children also stand to inherit?
Advocate Maragi, can you assist? There is a case, but I don't remember the name because I don't want to. There is a case. Do you remember the case about the adopted children?
No, I don't remember. I don't remember the case. But what is happening practically is that when it comes to adoption, we are referring to the legally adopted, not the traditional adoption. I don't know if there's any case regarding that.
Thank you for that. The next question is, who is a spouse for the purposes of intestate succession?
Okay. It has been explained who is the spouse for when we're going through our presentation. But I am sure that question comes up because of the recent case of Jane Banywa, case wherein there is a decision about the discrimination of the Intestate Succession Act as well as the Maintenance of Surviving Spouse Act, that those acts are unconstitutional. Previously, the spouse were those that were married. But there is this recent case that I'm talking about, the Banyo. I'm not sure whether I should state the citation or just to explain about it a bit. Hello?
You can do, yes, you can do.
Okay. Previously, the spouse, we meant those that are married. There is now a recent case, which is there is a Western Cape. It was held at Western Cape. There is a decision that has been handed down, which is reported, case number 20357 of 18. In that case, Banywa approached the High Court with assistance because when the estate was lodged, she couldn't inherit because she was the girlfriend. I could put it that way. That is the girlfriend because they were not married. But now, because they approached the High Court, they stated all the reasons or whatsoever, stating that the definition of the survivor or spouse and marriage in terms of the Maintenance of Surviving Act 27 of 1990 are unconstitutional in that they exclude partners in permanent opposite sex life partnership from claiming maintenance in terms of the Act. They've also approached the court about the Intestate Succession Act. That is also unconstitutional in that those that are living together and who have aims of being married together, they're excluded in terms of the Act. That the word which says spouse, wherever it appears, that word they believe that it's unconstitutional, because now it should read as those that are married in which are spouse or partner in a permanent opposite sex life partnership in which the partners had undertaken reciprocal duties of support. So because of that case, because currently we're not aware whether the family of the deceased will take it to Supreme Court or not, but currently we're sitting with this case that is telling us that the Act is unconstitutional. So those that are intending to marry, they should also be included in terms of the Intestate Succession Act.
Thank you very much, Tembela. The next one is the Black Administration Act still applicable today?
No. We now have Master of the High Court. Those days, we no longer administer in terms of the Black Administration Act because that act was also unconstitutional in a way that we would say the eldest child is going to inherit and will take care of the of the elder children. But those things were not happening, or else it goes back to say those that are married in customary, the first wife is the one that is going to inherit. All the other wives, we have to bow to the first wife. No, now we're having the Administration of Deceased Act. We all now go to the Master of the High Court. At court now we have service, we call them service points, the offices. We administer everything in terms of the Administration of the Deceased Act.
Thank you. And the next question is, why is it compulsory to appoint an attorney to help if the amount of the estate exceeds 250,000 Rand?
Okay, I can't say it's compulsory. If, for instance, you're an accountant or someone that has the background of law, if you are, you will be able to follow all the sections. Remember, there are sections. We didn't all study the law. Somewhere, somehow, you won't know what the section says, what the section wants you to comply with. That is the reason we always advise people to have an attorney, but not in particular, as I've said, an attorney. That's why we always say, have someone that will assist you in finalization of the estate. We don't say, go and have an attorney. You must have someone that will assist you in finalization of the estate.
Can I add on that?
Yes.
When you add when the estate exceeds 250,000, that's where you have to. It's an attorney, a trust company, or a registered chartered accountant. We have a regulation 910 which prohibits advocates from administering estates. So even if you have a legal background, as long as you don't fall within the ambit of an attorney, a trust company, or a registered chartered accountant, we won't issue with letter of execution. We will need somebody who is qualified to come and assist you.
Thank you, Advocate Morake. The next one is, does the intestate succession recognize polygamous marriages? Why must attorneys be used in estates, and what do you think of mediation as ADR?
You're asking if the act includes polygamous marriage?
Correct. Does it recognize polygamous marriages?
Yes, it does, as it goes back again to the presentation that was done by Advocate. It recognizes those that have one or more wives because of the case, of the constitutional case decision of Bear. I've also made that example that if the party has 5 wives, there is a first wife up until the 5th. If the estate is the total assets after all the liabilities be paid, it's 500,000. The amount will be divided equally. So it does recognize the customary. And it doesn't say the first wife is going to get the higher amount and the 5th wife is going to get a little amount. You all inherit equally.
Thank you, Tembela. The next question is, can you explain how the estate advertising process works in terms of disputes from third parties?
The advertisement?
Yes, the question is, can you explain how the estate advertising process works in terms of disputes from third parties?
Can you come in, Advocate Morake, because I don't want to explain about section 29 and 35. I'm not clear about the question, so I don't want to go.
When it comes to advertising, the only advertisement we have is section 29 advertisement, where you are inviting the creditors. After advertising section 29, you prepare L&D account. You submit it to the master for examination. If the master gives you approval to, if they grant you permission to advertise, you advertise it again, section 35. It's 35.4 and 35.5. 35.4, the account is going to lie for inspection at the local magistrate. 35.5 is at the local newspaper. If we don't receive any objection after 21 days, remember the 29 is 30 days, the 35 is 21 days. After the 21 days, there's no objection. The executor must give the master magistrate certificate, which will confirm that there was no objection lodged against the estate. They must also submit the newspaper clip to show that the account was advertised and there were no at the local newspaper. If there are no objections received, then we give you permission to finalize the estate. You distribute the estate. That's all the advertisement we have.
Thank you, Advocate Morake. The next one is, does a stepchild have a share in the joint estate? Is there an age limit of children when it comes to inheritance? Does the law consider the age of the kids and apportion according to their needs? For example, if there are younger kids still going to school and older kids who are considered adults, will they inherit equally or no?
Okay. With that, first of all, I'll go to our constitution, which is section 9, equality. We have section 9 that speaks about equality. So even when it comes to the estate, if the residue is, let's say there's no spouse or no spouses and there are only children, two it's major children, but the amount is 1 million, and 3 is minor children. All of those children are going to inherit equally, regardless whether the younger one is 2 years and you are 50 years of age. You all going to get 200,000 each, which is equally. For the minor children, the money will go to the guidance fund because those children are still minors. They are under the age of 18. Those that are over 18, which we call them the major, the money will be paid directly to their accounts. I think you had 3 questions. I've answered 1. I'm not sure.
I think you've answered them. Just you've answered the consideration of age as well as whether they will inherit equally. Thank you. The next one is a statement or a question saying, what if the children do not want to sell the property, but they want to take over the bond payments and keep the house, and the divorced mother has no objection to this?
What if the children doesn't want to sell the property?
Yes, and they want to take over the bond payments and keep the house.
So, okay, in this case, is the parent or it's only the children that have been, that are the heirs?
It's not clear. It just says, what if the children do not want to sell the property, but they want to take over the bond, and the divorced mother has no objection?
Okay, then I'll just make examples. It's fine. If you don't want to sell the house, it's good. It's good if you want to retain your home, which is perfect, as long you will be able to continue with payments. Because remember, you can't just say, I want to keep the house, and at the end, you don't have the money, because it would go back to wherein there is now an attachment by the bank because you can't afford to make the payment. But when it comes to the distribution, there is a house, and for instance, the other party, which is the spouse, it was entitled to 500,000, and you as the children, for instance, were entitled to 300,000. If you are able to buy, we call it, you buy the other party. Sorry, if you are able to buy him or her out, you can do that. It goes as well to the children. Let's say if in an estate there are 4 children, and one child wants to sell the house because this child is desperate of a cash. If the other 3 children doesn't want to sell the house, those 3 children that doesn't want to sell the house, they can buy the one that wants to sell the house. They can buy him or her out, meaning they are paying him his or her share. with the value, because if the value of their house is 200,000 and there are 4 children, then you'll have to pay him or her out the 50,000. The 3 that wants to keep the house, they can keep the house.
Thank you.
And be registered in their names. Okay.
Thank you very much. The next one is, do estates matters prescribe? Please explain the letter of authority and the letter of executorship.
Okay. Letters of authority, it's when the value of your estate is less than 125,000. For instance, you report, sorry. Oh. Okay. For instance, you report an estate and then at master's office, you collect all the assets of the deceased. When I mean the assets, let's say there's car, there's money, or else there's only monies at the bank. Then when collecting the assets, then the total value is 250,000. If the total value is 250,000, it means the master of the High Court will issue a letters of authority because the value of the estate is less than 250,000. And that one doesn't need an attorney or an accountant. But if you go to the master of the High Court reporting an estate, and when completing an inventory, it transpires that the deceased, let's say for instance, there's money that the bank is 100,000, got a house, the house is 250,000. Now, obviously, when you add those two amounts, is now 450. If it's more than 250,000. So it's more, if it's more than 250,000, the total value of the assets of the estate, that's when a letters of executorship must be issued. So the difference, it's about the value of the estate. If the value is 250 less, we'll issue a letters of authority. If the value is 250 and more, we'll issue a letters of executorship. When it comes to I think the second question was about prescription.
Yes.
Okay. Prescription, it doesn't prescribe. But remember, this is how it's going to work. If your parents have left a house and then you're sitting in that house and not paying any municipal bills or whatsoever, you don't even go to master's office to report the estate. Somehow in the long run, the municipality will switch off the lights, will switch off the water, dragging you to go to the master of the High Court to report an estate. So it doesn't matter even if this thing happens after 4 years or 3 years, but at the end, you'll be incurring the liability for sitting and not reporting an estate. Hence, I've said from the beginning, it's important to report an estate immediately when you know that someone has passed away, because there must be someone who's going to take control of the assets and liabilities of the deceased.
Thank you very much. Our next question is concerning the removal of an executor. What if the cause of the delays are because of poor responsiveness at the master's office? Can the master still remove the executor?
If the delay is with the master's office?
Correct.
Advocate Mareke, master's office.
If the delay is caused by the master doesn't have the right to remove the executor, meaning the master wouldn't be performing his duties. I mean, the master's duties is to supervise administration of the estate. So I don't understand how maybe the master can delay in responding maybe to the post which was sent. But if there is no communication between the executor and the master, then the master can remove the executor for failing to administer the estate properly. But the master doesn't have a right to remove the executor if the master is the one who is at fault.
Thank you, Advocate Morage. Our next question is, can a paralegal working in an advice office be appointed executor of the estate?
No.
He already explained. You can explain again what you explained previously.
Meaning, let me understand the question. The paralegal to come and assist to administer the estate. Is that what the question is saying?
The question is, can a paralegal working in an advice office be appointed executor of the estate?
If it's nominated by the will, yes. To be an executor can be nominated by the will. When it comes to intestate, to be the executor, you must be related to the deceased. The spouse qualifies to be the executor. The children qualifies to be the executor. The parents qualifies to be the executor. Any individual apart from those are prohibited unless they give us bond of security to the full value of the estate. Then that's where they will qualify to be executors. We will need bond of security from them.
Thank you. The next question is, if I marry someone in community of property and the other in customary law, who will inherit? How much fees or percentage is paid to the executor of the estate? And can maintenance be claimed from the estate of the deceased? Shall I repeat the question?
Yes.
Yes, please.
If I marry someone in community of property and the other in customary law, who will inherit? How much fees or percentage is paid to the executor of the estate? And can maintenance be claimed from the estate of the deceased?
Advocate?
The executor's fee is 3.5% from the total value of the estate. Maintenance, yes, can be claimed from the deceased estate. If you are married in community and customarily, that is not, I just mentioned the case here of Mayelani versus Ngwenyama. Meaning, if the customary wife, the first wife, the one who's married in community of property, gave consent to that customary marriage, yes, it will be a valid marriage. But if there was no consent from the first wife, meaning that marriage is not valid. But the one married in community of property will get a half share in terms of marriage in community. Then the customary one will get the child share. They will both get the child shares.
Can I come in as legal aid when it comes to the fees?
Yes.
Okay. Legal aid have an agreement with the Master of the High Court. If the estate involves the minor children, Master of the High Court will refer the matter, which is the estate, to legal aid to assist. So even if there are 5 adults, but there is only 1 minor, by virtue of that the estate, there is a minor child, they would refer you to legal aid. At legal aid, they will assist you with your estate, with the finalization for free because of the contract that legal aid have with the Master of the High Court. So if there are minor children involved, feel free to come to legal aid because there is a contract between legal aid and the Master of the High Court that legal aid must assist for free if there are minor children that are involved.
Thank you, Demela. We have a few more questions left. Can the estate be forfeited to the state, and how does this happen?
Okay. When it comes to forfeit the estate to the state, the reason for that, it means if we're speaking of an intestate, if a person die intestate without leaving any person capable of inheriting from him or her, According to our common law, in such cases, the estate acquires the whole estate as the whole estate. The matter now will be regulated by Section 3513 and 92 of the Admin Act. This is the procedure. It means the procedure is that where the estate heirs are unknown, remember I've said unknown, and where there are no intestate heirs, the executor will convert the intestate estate into cash, and after payment of the deceased debts, pays the residue to the guidance fund. If nobody is able to prove that they have a claim to the money as an intestate heir of the deceased, then after 30 years have lapsed, after payment of the funds into the guidance fund, the money will accrue to the estate. That's what was Advocate Moraka, I think he explained it at the beginning. So that is the procedure. The state, it doesn't just take your money. We follow the procedure first.
Thanks for that. The next question is, does the L&D include the liabilities of the spouse in a community of property? If the spouse's creditors keep calling, even after they have been informed about the joint estate and refuse to accept this, how should this be handled?
If they are married in community.
Correct.
Okay. The consequences of a marriage in community of property, it means mine is yours, yours is mine. It goes as well with the liabilities. So it means that both your assets and your liabilities will have to be included in an L&D account. When it comes to the creditors, most of the creditors are aware how it works when it comes to the L&D account or whatsoever. So it means whoever that is appointed in an estate, the creditor, let's say your creditor is a clothing shop. That clothing shop will write a letter to master's office or else phone master's office to find out who has been appointed in this estate. Then you just tell them whoever has been appointed, if it's an attorney or else is whoever that has been appointed, they must lodge a claim against the estate. So there are procedures that must be followed. If you are aware that the estate has been reported, they have to lodge a claim to the executor of the estate, which claim will be accepted or rejected, because if you don't prove your claim won't be accepted. You have to prove your claim.
Thank you very much.
They have to follow the correct procedure. Claim against the estate.
Thank you. The next one is, does the Interstate Succession Act have ADR as a means of mediation?
Okay, I'm not that 100% clear with your question, but when it comes to ADR, I would say maybe it's the heirs that are not in good terms. Maybe there's bad blood, or whatsoever. In that case, anyone can approach the Master of the High Court, maybe to tell that whoever, maybe my sister was appointed as the executor, but now she's not doing things according to the Act. So at Master's office, you go there, you meet with the person that is handling the matter, which is the estate controller. The estate controller will write a letter to all the heirs, calling them to invite them to the Master of the High Court so that the matter can be heard. They do that at Master's office to call the parties to mediate instead of entertaining the fights or take the matter up or whatsoever.
Thank you very much. The next one is, can you validly enter into a civil marriage with one spouse and customary marriage with a second?
Advocate Mareke, please repeat your case that you spoke about again.
It's Mayelani versus Ngwenyama. Mayelani versus Ngwenyama.
They need more. I think they didn't hear you.
Now I'll explain it again. Yes, you can marry, but the customary, the civil wife must first give consent to that customary marriage. If there's no consent by the first wife, then that marriage is null and void. I don't know if I've answered him correct.
Thank you, Advocate Morake. The next question is, please explain the procedure of reporting the deceased estate to SARS.
Okay. You don't just go to SARS to report the estate. The first office that you enter to is the Master of the High Court. SARS, at all instances when you approach SARS, first question SARS will ask you, who is the executor or the executors of this estate? Hence, your first door will always be the Master of the High Court if someone passes away, because there must be an appointment letter. In a case wherein the assets again are less than 250,000, you obtain the letters of authority, but you know that the deceased maybe owes SARS or whatsoever, you can go and approach SARS and they would see if there is any money, because remember SARS is always a preferred creditor, so SARS must be paid. But if there are no monies, then SARS won't be paid, obviously. In a case wherein there is an attorney that is involved or accountant, because the assets is more than 250,000, it goes now to that part of advertising the estate, calling all the creditors. But because the asset is more than 250,000, one of the requirements from the master's office when they issue a query sheet, SARS, they have to be involved, because that there is a document that you're going to complete for the estate duty calculating. There is a calculation that has to be done. Hence, someone who is an attorney has to assist you. That one of reporting to SARS, it would be done after an appointment letter has been issued. But if you don't owe SARS, if the person was earning less money, doesn't owe SARS, then you don't have to report to SARS.
Can I add on that?
Okay.
Can I add?
Yes.
The procedure also, you don't have to report an estate to SARS. What is happening is that after we have examined L&D, liquidation and distribution account, we have a SARS office within the master's office. There's somebody from SARS who make copies of all the L&D accounts. Then those accounts are the one going to SARS. If there are issues at SARS, SARS will communicate with the executors. Thank you.
Thank you. Tembela, I think you touched on this in an earlier question. What can we do if estate controllers are not responding to an attorney in respect of a reported estate? It has been 10 months.
If the estate controller,
yes, are not responding to an attorney in respect of the reported estate.
Advocate Morake touched on that.
Then the matter must be escalated to the supervisor of the estate controller, who would be the assistant master.
Thank you. There's a question around saying that there are extreme delays at the master's office due to COVID-19. When will this be rectified?
I think it will be rectified as soon as we are operating fully at level 1. Because we are all adhering to the COVID regulations. And yes, I do agree with the delays.
Thank you for that. From the advice officer's perspective, we have attorneys who charge 25% in fees as contingency. Is this allowed?
Contingency fee, I think, is the agreed fee between the attorney and the client, not including the estate. From the estate, you only charge 3.5%. The contingency fee, it would be their agreement on the side.
It's for any claim, other claims. Like for instance, in case of if you're suing the state or RAF, the attorneys, private attorneys like to do that, to say, I'll take the contingency fee. As he explained that with estate, we guided by the Act, and the Act says 3.5, but from 3.5, it can go down to 2%. Let's say the estate is done by someone that you know, and that person can say, okay, it's fine, I'll charge you 2.5 instead of charging you 3.5 or even less.
Thank you very much. Nolita, I'm going to hand over to you. I think we've reached the end of our questions session. I don't see any further questions from the attendees. Thank you very much, Tembela and Advocate Morake.
Thank you.
Thank you very much, Ru, for fielding that session for me. I had connectivity problems, but you took over as if you were prepared to run with it. Thank you so much for that. At this stage, ladies and gentlemen, I'd like to thank our two panelists, Advocate Morake and Advocate Tembela van der Berg, first for agreeing to being with us on this session, and secondly for preparing so much. They were prepared and they were very ready for us. They went over and above the call. These are issues, what we discussed today are issues that we don't like to discuss at home, at work, and everywhere else. And when someone has passed away, we then start running around not knowing what to do. So we thank you very much for the thought-provoking and inspiring presentations that you made for us. And I've also just been reminded to just go and update my will. I think I last did it in 2005. As that will clearly indicate what my wishes are at the moment, because I think they have now changed. To the attendees of this session, thank you very much for joining us. We hope that this session has helped you a lot, and we want to say it wouldn't have been a success if you hadn't joined it. So thank you very much, and we hope that you have a clearer and a better picture now of what happens when one of your loved ones passes away. To the organizers of this event, continue to do this great work. We are behind you, and thank you very much for what you've done for us and for the communities. Ladies and gentlemen, as I said earlier, the LSSA has organized attorneys who are willing to assist those who want to draw wills. So just go to www.lssa.org.za and scroll there, and you will find the name of an attorney that's closer to you if you are scared of what you've heard today, because I am. Go make an appointment with the attorney and go and draw a will. It makes life very easy for your loved ones. On that note, ladies and gentlemen, I wish to thank you very much. This brings us to the end of the session. Bye.
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 Bye.